So continuing on with our discussion, I already mentioned with the Civil Rights Act of 1964, but just to reiterate, any state or local government that practiced discrimination would lose its funding according to this. So this is a huge change. Also, there's going to be some follow-up legislation that sort of extends on the ruling of the Civil Rights Act. So the Open Housing Act of 1968 makes it illegal to discriminate in housing sales and rentals. Okay, so voting rights, again, going back to the Civil Rights era, the Reconstruction era, that is. Going back to 1870, the vote for African Americans was originally granted with the 15th Amendment, but as you probably remember from U.S. history, it was quickly ignored and also not implemented by individual states. And so these individual southern states, they all implement normally several of these different tactics. Poll taxes, which basically meant that in order to vote, you had to pay a tax. Literacy tests, which meant you had to prove that you could read in order to vote. White primaries, which basically only limited the primary vote only to white voters. It's important, going back to literacy tests for a minute, to know that white people weren't subject to these literacy tests, so there could be illiterate white voters who would just walk in. So again, it takes a while on the road to suffrage after the 15th Amendment was essentially ignored by southern states. But some accomplishments that lead us down the road towards suffrage: the 24th Amendment, which outlawed poll taxes in federal elections. All right, and then 2 years after the 24th Amendment was ratified, you have poll taxes become illegal in states as well. All right, so this is an important accomplishment by the federal government here. Also, in the 1960s, you have, I didn't mention that the 24th Amendment was ratified in 1964. So the Voting Rights Act the next year of 1965. Okay, so this actually sort of, this immediately follows the Civil Rights Act of 1964, which we already discussed. So what this does is it now makes it so that the government can't use any procedure. All right, we know that the 24th Amendment made poll taxes illegal, but now literacy tests, grandfather clauses, basically anything that the states previously tried to use to deny people the vote based on color now were illegal. It's important also for us to realize that the Voting Rights Act was very successfully implemented because immediately registrars were sent to districts that had really long histories of discrimination, and they very quickly worked to register African American voters. Also, the government effectively used election inspectors to prevent discrimination. So it's important for us to realize that that the Voting Rights Act worked pretty quickly, and it's a really good example of successful implementation. I believe we mentioned this in the bureaucracy chapter, because we know that implementation of policy can be difficult, but the Voting Rights Act is a really good example of implementation that worked. A lot of this was because the government instituted or worked to send these registrars. Sorry, you can't see this. I don't know if you can see this down here, but basically this last point here just says that the government could use election inspectors, which is something I said, and something that I will include in the notes that I will share with you. So quickly, it's important also to realize that civil rights laws have benefited members of other minority groups, such as American Indians, Asians, and Hispanics. 1924, Native Americans officially became citizens and were granted the vote. The Indian Bill of Rights. Basically, what this does is it allows the Bill of Rights, our first 10 amendments that we know well, it applied these to Native American tribes. It's important for us to realize, though, that some Native American groups actually have been given some exemptions to certain laws or certain legal obligations that other citizens are required to do. For example, there can be gambling facilities on Native American reservations. Some Native Americans are exempt from certain taxes as well. Hispanic Americans, they, as you probably are familiar with, are the largest minority group that exists in the United States. They, like African Americans, used very similar tactics to try to gain civil rights. It's important for us to realize that civil disobedience was one of the really important strategies that ultimately brought civil rights legislation to the attention of the federal government. So they also engaged in things like sit-ins and boycotts. Cesar Chavez is an important person to be familiar with because he brought attention in particular to the plight of migrant farm workers. They tended to be denied basic civil rights much more than other groups of Hispanics. An important Supreme Court case to be familiar with is Plyler versus Doe, which made it illegal for illegal immigrants to be denied enrollment in public schools. Asian Americans, with the exception of Korematsu versus U.S., which was decided during World War II, this actually upheld internment of Japanese Americans. But we know that during a time of emergency, which you could constitute the World War II period, civil rights tend to sort of take a back burner. But Korematsu versus U.S., you could say, is a little bit of an exception to the rule. Now in the 20th century, Asian Americans tend to be treated pretty equally under the law. This was not the case prior to World War II, however. Going back to the 1890s, the Chinese Exclusion Act actually denied citizenship to Chinese Americans, and we see Korematsu versus the United States being discriminatory towards Japanese. Arab Americans and Muslims, again, sorry, this may be cut off down here, but this last point says that they have actually still been victim to bias-related attacks, and a lot of this is because of the wake of the 9/11 attacks. Okay, so how have women sort of been treated throughout history? How have civil rights applied specifically to women? Women, this is sort of a 19th century term, but women used to be subject to the idea of coverture, or you could think of a covered woman, of a protected woman. In the 19th and even up until the early 20th century, women were not considered separate legally from their husbands. One of the reasons why women couldn't vote. The battle for the vote actually really began early in U.S. history. You could say it really paralleled the abolition movement, which was born in the 1830s. But women continued to take the back burner. Because many, very prominent events in history sort of eclipsed their efforts, like the Civil War and World War I, for example. But the 19th Amendment was finally ratified in 1920. What it did was grant women's suffrage for all, but it's important to realize that as Western states were incorporated into the Union prior to that, many of them allowed women's suffrage. Some of this was actually because the populations of these Western states were quite small. So the 1920s to the 1960s, after women gained the right to vote, this does not mean that they are finished in their quest to gain equal civil rights. You found that actually there was, I guess, sort of a divergence in some women's goals after the 19th Amendment. The Equal Rights Amendment was originally proposed in the 1920s, but as we already discussed, it was not ratified by the states in 1972. There were some women who actually argued against the Equal Rights Amendment. Some of them said that things like, well, first off, that all women would be subject to the draft. This was something that certain women feared. Other women tried to use scare tactics to say things like public restrooms would now be unisex. So ultimately, we know that the ERA ultimately fails. The 1970s classified as second feminist movement. It's important for us to be familiar with a few figures here, like Betty Friedan, who was the famous author of The Feminine Mystique, who sort of pointed out the ongoing problems of married women, sort of an unnamed problem that married women face in the sense that they are continuously subject to unfair treatment under the law. Also, the National Organization for Women, or NOW, was established in the 1970s. An important civil rights case to be familiar with was Reed versus Reed of 1971. And this ruled that a sex-based classification that was arbitrary in nature violated the Equal Protection Clause of the 14th Amendment. What Reed versus Reed dealt with was a divorced couple, man and wife, or former man and wife, who both wanted to administer their dead son's estate, and this was in Idaho, and there was a law in Idaho that preferred males to females in this case. Mrs. Reed argued that this was that this was unconstitutional, and the Supreme Court ultimately struck down this law and said that that classification was arbitrary in nature. Another case is Craig versus Boren, which is where the court establishes its medium or intermediate scrutiny standard, which basically says that if there is sex classification under the law, it's not immediately presumed either valid or invalid, right? So you see that certain laws, like, again, women not being subject to the draft, are things that actually can be upheld by the court. So basically, if there is a law that regulates in a sex discriminatory fashion, it needs to serve a compelling government interest, like the draft arguably does. All right, and another thing that Craig versus Boren establishes is that sex-based classification actually receives less scrutiny than race-based classification. Going back to the Civil Rights Act of 1964, another thing that it does is it bans gender discrimination in work, which is obviously important. The EEOC, which we already discussed, also was given power to sue employers who were suspected of discriminating against women. Again, sorry, this is not cut off. The Title IX provision of the Education Act of 1972, we know, also prohibited sex discrimination in federally subsidized education programs, which included athletics. But wage discrimination actually continues to be a significant problem. It's a huge controversial element in gender equality. The court actually has been kind of silent on the issue of comparable worth. In other words, women, we know, are statistically paid less than men, even if their jobs demand the same kind of skill. So, it's important for us to realize that this is an ongoing problem. Sexual harassment. This has been deemed a form of discrimination as of 1986 by the Supreme Court. A couple of cases that relate to, these are not actually listed here, but I'll mention these in your notes. One case that deals with sexual harassment is Harris versus Forklift Systems in 1993. What this said was, if a workplace was determined to be violating Title 7 of the 1964 Civil Rights Act, it was seen as hostile and abusive in nature. Also, there's Farragher versus the City of Boca Raton, which was in 1998, which said if there was an instance of sexual harassment by a supervisor, that the employer was ultimately held as liable. All right. So basically, the idea is that women now are a little bit safer to file claims of harassment. They're safer from getting discriminated against or getting fired by their employers. We also know that access to the military has sort of been expanded as time has gone on. However, women still serve in separate units from men. Women are not required to register for the draft, so we know that falls into the intermediate scrutiny type of judicial scrutiny for classification in the law. Women also have been restricted to a certain extent for serving in active combat. But women still play important roles, such as airline pilots, and we're going to see that there are actually plans to limit combat restrictions starting next year. All right, so we'll finish up with the other groups that fall under the civil rights umbrella with the next and final video, and that should cover Chapter 5 for us.